Namaste, I am Anil Goel from AAA Insolvency Professionals LLP. We are a full service insolvency law firm and also we are an insolvency professional entity. This is our voice 16 from our series called The Courtroom Voices. And today we are discussing a voice from the courtroom which was delivered on 29th August 2024. That was from Appellate Tribunal NCLAT, Principal Bench, New Delhi, and the name of the applicant in this case was Asha, Chopra and others. And the name of the respondent was Hind Motors India Limited. It was in the CIRP process of Hind Motors India Private Limited, and the prayers from the applicant was that the applicant in fact sought reliefs. 1. Directions to the liquidator to call a meeting of the committee of creditors to consider the applications submitted by the applicants under section 12A of the IBC. In fact, the application was submitted during liquidation process. So calling a meeting of committee of creditors, something which is incorrect. Second prayer was a stay on the sale of assets of Hind Motors India Limited initiated by the liquidator, particularly challenging the sale notice issued by them, and a declaration that the liquidator's action, including the sale of assets without constituting a stakeholders consultation committee, were illegal and in violation of IBC, the liquidation process. Now the facts of this case are very important. First, the promoters will submit an application in March 2017 under section 10 for the insolvency of Hind Motors India Limited. And then in September 17, an order of liquidation was passed by the adjudicating authority. In April 2018, an appeal filed by the promoters and the former directors challenging the liquidation order, which was dismissed by NCLAT. In August 2019, an application by the former directors to stay the sale of assets were rejected by NCLT, which was later upheld by NCLAT. Then in May 2021, the applicants who claimed to be the depositors of the corporate debtor filed an application under section 12A of the IBC seeking withdrawal of the CIRP. Now, starting from 2017, first they are filing an application under section 10, then they are contesting that the liquidation should not happen, and they are getting rejections everywhere. They also objected to the sale of assets, that also was rejected. Then the liquidator issued sale notice, that was also objected and that was also rejected. Now in May 2024, the NCLT rejected the applicant's IA, ruling that the application under section 12A was not maintainable. When they could not get any relief, then they finally submitted an application under section 12A while the company is under liquidation process, not in CIRP. The applicants argued that their application under section 12A for withdrawal of CIRP was maintainable even during the liquidation process. They were also challenging all the actions of the liquidator. They contended that the liquidator's actions, including proceedings with the sale of the assets without constituting an SCC, were in violation of IBBI liquidation process regulations. They were in fact relying on some of the precedents. In fact, they referred a judgment having a citation as V. Navaneeth Krishna versus Central Bank of India from Coimbatore, where in that case the appellate authority NCLAT observed that an application under section 12A might be considered even during the liquidation period. Now, the main issue in this case is the maintainability of section 12 application during liquidation process. NCLAT observed that an application under section 12A of the IBC which allows the withdrawal of a CIRP upon approval of 90% of the committee of creditors would be considered even during the liquidation process. This was in fact an observation of NCLAT in the case of V. Navneet Krishnan versus Central Bank of India. That was a judgment of 2018. Now, in this case, the tribunal noted that if a resolution plan or a settlement is proposed which could satisfy the creditors and bring the corporate debtor back into the resolution process, such a proposal should not be dismissed solely because the liquidation process has commenced. This was the observation in 2018 case. Now, the decision highlighted the possibility of withdrawal of the CIRP under section 12A if the COC with the requisite majority decides that it is the best interest of the stakeholders to allow withdrawal even during liquidation. Now, the flexible interpretation of that order of NCLAT, the judgment in fact demonstrated the tribunal's flexible approach in interpreting the IBC, emphasizing that the primary objective of the code is to revive and resolve insolvencies rather than to liquidate companies. Then tribunal thus supported the idea that section 12A should be available as a remedy even during liquidation if it serves the purpose of resolution. Now the respondents, so all this what I said are the arguments from applicants, and also they have picked up their arguments from that judgment of V. Navneet Krishnan, 2018 judgment. Now the respondents are saying, which is also represented by the liquidator, that once the liquidation process commences, an application under section 12A for withdrawal of CIRP is not maintainable. Adherence to the liquidation regulations also, the liquidator contended that the stakeholders consultation committee constituted was not required in this case, because see, this was also one of the allegations that the liquidator has not even constituted SCC, and the liquidator could not constitute the SCC because this case, in fact, when this case started the liquidation, at that time the constitution of stakeholders consultation committee was not on the law. The liquidator in fact very clearly said that that particular law is not applicable to me. The constitution of SCC is not applicable to me because the liquidation started much before this amendment came in the liquidation process regulations. So therefore, the basically two law points: whether an application under section 12A of the IBC for withdrawal of CIRP is maintainable after the commencement of liquidation proceedings, and second, whether the liquidator was obliged to constitute the SEC as per the amended liquidation process regulations, given that the liquidation commenced before the amendment. Now the judgment which is relied is again Navneet Krishna versus Central Bank of India 2018 judgment. Applicant relied on that judgment, and the 12A application can be accepted in liquidation process. The other judgment which was also referred by the applicant was Lokhandwala Kataria Construction Private Limited versus Nisus Finance and Investment Managers, and that was also referred by the applicant. Now the NCLAT held two things. One, that they dismissed the appeal. They held that this 12A application is not maintainable after the commencement of liquidation process. Secondly, the SCC cannot be constituted because this SCC amended regulations came only after the liquidation process started. So therefore, though the two clarities that the NCLAT has given, and also kind of observing that 2018 judgment was not correct. In that judgment, it was observed by NCLAT that the 12A applications can even be accepted during the liquidation process. Now, we have the clarity, one, that the 12A is not applicable during liquidation process. Number two, the stakeholders consultation committee cannot be constituted if the liquidation started much before the amendment in liquidation process for the purpose of constitution of SCC. So this is the importance of this judgment. Thank you very much.